Okay, what we're talking about today is taxes, okay? There's four kinds of taxes. There's direct taxes, indirect taxes, excise taxes, and duties. And this is taken from Black's Law Dictionary, 8th edition, as talking about excise tax, which is a privilege tax. Excise tax is a tax imposed on the manufacture, sale, or use of goods, such as cigarette tax, or on an occupation or activity, such as a license tax or an attorney occupation fee. So an excise tax is a privilege tax. And this is taken from the U.S. Supreme Court, license tax cases. And the requirement of the payment of such licenses is only a mode of imposing taxes. So I guess what the point I'm trying to make here is that licenses and taxes work together. You cannot have a tax without a license, and you cannot have a license without a tax. Although what they do a lot of times, when they first do the licenses, they'll make it free, because they want to get you used to getting a license, and then they'll start taxing it after they've got you used to it. So that does happen. But anyways, so let's continue on with this site. It says the requirement of the payment for such licenses is only mode of imposing taxes on the licensed business, okay, and the prohibition under penalties against carrying on the business without the license is only a mode of enforcing the payment of such taxes, okay. So and this is important because it's only for businesses, okay. This is what you have to understand, and we're going to go through this again and again during this presentation. Taxes are only for businesses. And then it goes on. It says the recognition by the acts of Congress of the power and right of the state to tax, control, or regulate any business carried on within its limits is entirely consistent with an intention on the part of Congress to tax such business for national purposes. And so, again, this is talking about businesses, okay? And so taxes are only for businesses, for things that are created by the government. And that's the U.S. Supreme Court license tax cases. This is Bouvier's Law Dictionary, 1843 edition. Volume 2, page 53. It says, a license is a contract. Yes, it is a contract, as a right given by some competent authority to do an act which without such authority would be illegal. The instrument or writing which secures this right is also called a license. License is express or implied. An express license is one which in direct terms authorizes the performance of a certain act, as a license to keep a tavern by public authority. An implied license is one which, though not expressly given, may be presumed from the acts of the party having the right to give it. Now, think about that. So, a filing fee in a court is a license, because think about it. What happens is you're allowed to proceed in the court, so it's an implied license for the privilege of proceeding in their so-called court, and it's only for businesses. And so again, you know, that's exactly what's going on, okay? A filing fee is an implied license in the court for the privilege of proceeding in their so-called court, and it's only for businesses. If it were true that according to the spirit of our Constitution, the power of taxation must be limited by the right of representation, whence is derived the right to lay and collect duties, imposts, excises within this district. If the principles of liberty and of our Constitution forbid the raising of revenue from those who are not represented, do not these principles forbid the raising of it by duties, imposts, and excises, as well as by direct taxes? And so, and this is Longborough versus Blake. This is a U.S. Supreme Court case. Now, this is talking about the District of Columbia, but the important thing to understand here is that it's talking about the four kinds of taxes. First of all, duties, imposts, excises, and direct tax. And it's also saying that there's no taxation without representation. And that's extremely important, because when I file my paperwork, when I serve it on anybody, I tell them, if you think you're representing me, you're fired. And so, again, because it's only with commercial entities, okay? Taxes are only applicable for businesses. This is actually a Canadian case, Ontario English Catholic Teachers Association versus Ontario, and this is the Supreme Court of Canada. And it says legislature expressly and clearly authorizes the imposition of a tax by a delegated body or individual, then the requirements of the principle of no taxation without representation will be met. Okay, so again, this is not unique to the United States. Okay, this idea of no taxation without representation has been going on for hundreds of years. Matter of fact, if you look at the Magna Carta, that's exactly what they were doing in the Magna Carta. They were representing people. They were putting people to their private law. That's why it says in I think it's one of the chapters in the Magna Carta says that we won't put anyone to their law without producing witnesses. And so the important thing is that this has just been going on for a long time. The issue is, therefore, whether the principle of no taxation without representation is respected by the EQIA, and it goes on. So the important thing is that there's no taxation without representation in the U.S. and Canada. This is another Canadian court case. Revolutions have been fought over taxation without representation. Well, not only yes, but heck yes. And the reason is I mean, the whole War of Independence was fought over taxation without representation. And so also the English Revolution, the Glorious Revolution with Oliver Cromwell, is the same thing. No taxation without representation. And in fact, the whether they had the slogan or not in the Magna Carta at 1215, it's obvious that that was what was going on. And this is another Canadian court case. The underlying part says this principle of no taxation without representation is central to our conception of democracy and the rule of law. And so, again, I cannot stress this enough. There is no taxation without representation. They have to represent you. And in every document I serve on them, I tell them, if you think you're representing me, you're fired. The government can only tax its own property. And this is actually a Canadian court case, Reference Re-Employment and Social Insurance Act, 1935. This is, now you got to understand, this is the Privy Council. This is when it was getting overturned. And, quote, in other words, Dominion legislation, even though it deals with Dominion property. Okay, so therefore, federal legislation, that's what they're talking about. Dominion legislations, federal legislation, deals with federal property. And this is the U.S. Constitution, Article 4, Section 3, Clause 2. Congress shall have power to dispose of and make all needful rules, regulations respecting the territory or other property belonging to the United States. So if they're taxing you, it's because that you're their property, or they think you are. This is an act to impose taxes in commerce only. This is George III, Chapter 12, 1778. Think about it. 2 years after the Declaration of Independence. And it says, whereas taxation by the Parliament for the purpose of raising a revenue has been found by experience to occasion great uneasiness and disorders. Well, no joke, Batman, that from and after the passing of this act, the King and Parliament of Great Britain will not impose any duty, tax, or assessment whatever payable in any of His Majesty's colonies, provinces, or plantations in North America, except such duties as it may be expedient to impose for the regulation of commerce, okay? Well, that was the same even before. It's all commercial. The only authority they have is commercial. And so think about it. They represent you. They say, oh, here's a commercial entity. Here's one of our slaves. Let's go collect our money. And that's exactly what they're doing. They're representing you without authority, and you ought to be firing them. If you think you're representing me, you're fired. This is a U.S. court case. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's right to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. Okay, so it's only corporations. It is absolutely only corporations. This is U.S. Supreme Court, Crandall versus Nevada. The taxing power, being in its nature unlimited over the subjects within its control, will enable the state governments to destroy the above-mentioned rights, okay? And so this is McCullough versus Maryland. This is the sovereignty of the state. All subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are exempt from taxation. This proposition may also be pronounced as self-evident. It's obvious. The sovereignty of the state extends to everything which exists by its authority or its permission. And the same case goes on to say the power to tax involves the power to destroy, okay? That's exactly what it is, okay? If they can take a penny, they can take it all, okay? That's exactly what it comes down to. If they can take a penny, they can take it all. It's slavery is what it is. Think about it. If you're forced to pay them even a penny, you're forced to work for nothing for that penny so you can give it to them. That's slavery. It's exactly what it is. It's just slavery. And in Title 15, United States Code, Section 17, it says the labor of a human being is not a commodity or article of commerce. Well, think about it. Why do you think that they want to know your occupation when you fill out a tax return? Why do you think? It's because they want to find out if you're a laborer or not, because labor is not taxable. And so what they do is anybody that does labor is, most of them are in the labor union, okay? That's a privileged status. And so either you're in the labor union or you're a aerospace engineer, you know. And so I always say that I get compensation for labor. And so that's important too. And this is actually a U.S. Supreme Court case, Eisner versus McComber. And I want to stress here, I've looked up this case, and it's unprecedented. I've never seen this in any case anywhere, but the bold and the underlining is in the original, okay? And so this is like very important. So let's look at this bold and the underlining. It says, well, let's look at the whole thing. It says it becomes essential to distinguish what is and what is not income according to truth and substance without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot by legislation alter the Constitution, from which it derives its power to legislate, and which within those limitations alone that power can be lawfully exercised. And it goes on, it says, income is derived from capital, the gain derived from capital. Here we have the essential matter, not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of exchangeable value severed from the capital, however invested or employed, and coming in, being derived, that is received or drawn by the recipient for his separate use, benefit, and disposal. That is the income derived from property. Nothing else answers the description, okay? And so income, think about it. Income is corporate profits. That's exactly what it is, okay? Taxes are in commerce only. It's for businesses. And this is Penhallow versus Doan's Administrators. Now, this is a summary of what this case says. If somebody wants to get in with it with me over this, they need to go and look at the case, because it's actually a summary of what the case says over about 2 pages, and I'll get in with it with anybody, and they won't like it when I'm done. Anyways, what it says is, inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. So that's exactly why they're busy fabricating evidence of the Satanic Trust, so then they can go and violate your rights and assault you. And if you go to this case at page 93, it says a distinction was taken at the bar between the state and the people of the state. It is a distinction I'm not capable of comprehending. And then it goes on for 2 pages and explains why he's not capable of comprehending. Okay, that's the actual cite of the case, and that is a summary of that cite. And so, you know, you get these lawyers, these brain-dead idiot lawyers that sit there and think that they can come and tell me that that's not in the case. Well, you know, don't get me going.